Yesterday, I had discussed with you Section 9 of the Code of Civil Procedure, which was a substantive section. Now, in that section, we had discussed the word territorial jurisdiction of the court is concerned. Now, territorial jurisdiction of the court is defined under Section 15 to 20 of the Code of Civil Procedure, wherein various provisions have been given as to where the suit can be brought. So, unless and until we go through section 15 to 20 of the Code of Civil Procedure, we will not be able to understand the territorial jurisdiction of the court is concerned. As far as section 15 of the code is concerned, it lays down that the suit has to be brought in the court of lowest grade. Now, as far as the grading of the court was concerned, when I joined practice 40 years ago, there were many type of courts. There were sub judges second class, sub judges first class, senior sub judge, etc. etc. But now that distinction was abolished. It was designated to civil judge senior division and civil judge junior division. Now, as far as civil judge senior division and junior division were concerned, same powers have been given, same pecuniary jurisdictions have been given to all the judges. So, as far as the territorial jurisdiction is concerned, so the court suit has to be brought in the court of a court which is of the lowest grade. Now, when we go to the hierarchy of the courts, first comes civil judge, then comes additional session judge, where the appellate court is there. Then comes Honorable High Court, wherein the regular second appeal and revisions etc. are filed, and then comes the Supreme Court of India, that is the apex court of India. There are four type of courts in India which are working. So civil suit has to be brought before the civil judge of lowest grade, who is civil judge, but working or holding the court in a particular district or tehsil. So once we bring the suit in the court, then we have to keep in view regarding the immovable property, because mostly the cases relate to immovable property. So as far as the immovable property is concerned, firstly, the suit has to be brought in a court within whose jurisdiction that property is situated, and it is subject to the pecuniary jurisdiction of the court is concerned, that will also govern that where the suit has to be filed. Now, as far as the commercial suits, now there has been a new act, Commercial Courts Act. In Commercial Courts Act, the powers have been given directly to the additional district judges or district judge, or a particular judge has been designated as the commercial court, where the commercial suits are as are maintained or filed, and commercial court has been defined in the Commercial Courts Act. So a commercial suit has to be brought in the said very court. However, as far as the jurisdiction of the court is concerned, if it is a suit regarding the recovery of the property or regarding rent or profits, mean profits, then it has to be filed where the property is situated. If there is a question regarding partition of the property is concerned, then foreclosure means the period of mortgage has expired and the mortgagee has become the owner of the property by a flux of time, or by sale of the property, or for redemption of the mortgage of the property. The suit has to be filed within the jurisdiction where the property is situated. If there is a right with regard to the human property is concerned, that has to be determined. Suppose a inheritance suit has to be there, then that suit has to be brought within the jurisdiction where the property is situated. If there is a suit regarding compensation regarding any damage caused to the immune property, then that has to be brought within the jurisdiction where the property is situated, or where the recovery of the movable property which is actually under restraint or distress has to be filed. Then where the movable property has been kept, it has to be filed within the jurisdiction of the court. If my car has been impounded by a person known as B and the car is parked at Ludhiana, though I may be having or residing in Delhi, I will have to come and file the suit at Ludhiana. So therefore, the basic mantra of filing of the suit is concerned is that where the property is situated, within whose jurisdiction the property is situated, that court will have the jurisdiction to entertain the suit. Now, as far as the question of suit for specific performance of the agreement of sale is concerned, now the property is situated within the state of Punjab. The agreement is executed at Bombay. The seller and the purchaser both remain at are residing at Mumbai. Then the suit cannot be brought within the jurisdiction of the courts at Mumbai. The suit has to be filed within the jurisdiction of the court where the property regarding which specific performance has been sought is situated. The suit has to be brought in that very court, though it may be stated in Ludhiana, Jalandhar, Amritsar, or any other district of Punjab, Haryana, Himachal, or anywhere. So it is not the residence of the parties which will govern the filing of the suit as far as the question of immutable property is concerned. Then comes the question of territorial jurisdiction. Suppose a suit has been brought in a wrong court which does not have the territorial jurisdiction. The suit is decided. The judgment will not be a nullity unless and until it is proved to the satisfaction of the court that there has been a miscarriage of justice by bringing the suit within the wrong territory or within the jurisdiction of a court which does not have the jurisdiction to entertain and try the present suit. So therefore, territorial jurisdiction will not render the judgment to be a nullity, but it can be treated as nullity unless and until it is proved that there has been a miscarriage of justice. So one thing you have to keep in mind is that where the immutable property is situated, all suits relating to immutable property have to be filed within the jurisdiction of that court. Now the second question which arises, that if there are more than one properties situated within the jurisdiction of two different or three different or four different courts, suppose suit for partition is there. A father was having properties at four places and he dies. After his death, the legal heirs want to partition the property. Then they are not required to file the suit in all the different courts regarding different properties. The suit can be brought within the jurisdiction of one court for partition of the property by including all the properties situated within the jurisdiction of the different courts. So there is no such bar. Then the bar of lack of territorial jurisdiction will not be applicable because one of the properties is situated within the jurisdiction of that particular court, and that particular court will have the jurisdiction to partition all those properties. Then comes place of institution of the suit, where the local limits of the jurisdiction of the courts are uncertain. This is a very rarely used section because the local limits of the jurisdiction of every court has been defined in India. There is no such place which is not defined, and as such, it cannot be said that we cannot ascertain with certainty that where the property in dispute is situated, but the legislature in its wisdom, because at the time when the Code of Civil Procedure was passed in 1908, there was a dispute or there was a doubt regarding the territorial jurisdiction of the courts, because certain states were under the British rule and certain states were under the uh, in the kingdom of rulers, kings, nawabs, etc. So, as far as the place of institution of the suit is concerned, then so far as it can be ascertained as to where the property is situated, the suit can be filed over there. Then the question comes, section 19, suit for compensation of wrongs to person or movables. Now, when the suit has to be filed regarding compensation to for a wrong committed to a person or movable, then it has to be filed within the local limits of one of the courts, or and the defendant is residing or carries on business, personally works for gain within the jurisdiction of the local limits of the court. So there are three things: that defendant is residing, one, or he carries on the business, or he personally works for gain within the jurisdiction of that very court. The suit can be filed. Then comes the last but not the least section, that is section 20, which can be called a residuary section, which deals with the with every type of suit. Now, as far as the limitations contained in section 15 to 19 are concerned, this section is subject to those limitations. The court within whose local limits the jurisdiction the suit is filed, I can always bring the suit where the defendant resides or personally works for gain or is carrying on the business. So at all the places, irrespective of the fact, not regarding the territorial jurisdiction as far as the property is concerned, that will always remain there. But I can bring a suit. Suppose I have to file a suit for recovery. I had supplied the goods to the defendant at Ludhiana, but he is residing in Mumbai or Calcutta or Chennai. Then I can file the suit against him at all the places where he works for gain, or he resides, or he is carrying on the business. So that jurisdiction has been conferred on the party to file the suit at the place where at the time of commencement of the suit he was actually and voluntarily resides or carries on business or works for gain. Then comes the second part, when at the commencement of the suit the defendant, where there are more than one, was residing or actually carries on work or voluntarily works for gain or personally works for gain, the suit can be brought within the jurisdiction of one of the courts, but leave of the court, permission of the court has to be sought by the person concerned, that is the plaintiff. He has to seek the permission of the court that please permit me to file the suit against one of the defendants, as there are more defendants who are residing within the jurisdiction of different courts, and it is not possible to split up the cause of action and bring the suits at all the other places where the defendants are residing. So please grant me the permission to file a suit at a particular place, and the court, after going through the totality of the circumstances and the facts of the case, may permit the plaintiff to bring the suit within the jurisdiction of one court, and then the suit is legally permissible. Now, then last comes when the cause of action wholly or in part arises. What does it mean? Cause of action. Or this is a new word. cause of action is a bundle of facts which cumulatively gives rise to a filing of the suit, which gives right to the plaintiff to bring a suit against the defendant. It is not a single fact. Now, how it is not a single fact? I'll give you an example. I lend certain money to the defendant. He executes a promissory note in my favor. He agrees to pay the amount to me within 6 months. He agrees to pay interest to me on the loan amount. Now, execution of the per note is one fact. Promise to repay the loan is second fact. Payment of interest is the third fact. Fourth is that he fails to make the payment to me. Then fifth fact is that I call upon him to make the payment. And despite my calling upon him or serving him with a notice to repay the amount, he does not repay the amount. Then all of those facts will cumulatively give rise to a cause of action for me to file the suit. Execution of a per note or promissory note or payment of interest, or if there is no refusal, or if there is no calling upon him to repay back the loan, will not give rise to the plaintiff to file the suit as against. Now, one explanation has been added to this section. Now, it is a year or era of multinational companies. Multinational company has a registered office at one place. It has branch offices at various places throughout India, throughout world. Now, how the suit has to be filed and where the suit has to be filed. So, it gives rise to a right to the plaintiff to file a suit at a place where there is a branch office of the said company or corporation. But one distinction is there. Suppose I get a connection of Airtel at Ludhiana. All the services are being provided to me at Ludhiana, and there is some default in providing the services. Then I cannot go and bring the suit at Amritsar. Why? The question is that I was not using the connection at Amritsar. Though in Amritsar, Airtel has a branch office. The existence of the branch office and the cause of action, accrual of the cause of action, are both to be taken into consideration to confer the jurisdiction on a court at a particular place where the corporation is having an office. So it is not there that I can file the suit anywhere against Airtel in any part of the country. However, one exception is there. If Airtel is having a registered office at a particular place, then I can certainly file the suit over there. There is no such bar. Then the cause of action will not come into picture. I have the right to file the suit where the company is having a head office. But as far as the branch office is concerned, the suit can be filed only if cause of action wholly or in part has arisen within the jurisdiction of that court. So to sum up, when we see the territorial jurisdiction of the court is concerned, section 15 to 20 of the Code of Civil Procedure becomes very much relevant. Now, as far as the objection regarding territorial jurisdiction of the court is concerned, then such an objection under section 21 of the Code of Civil Procedure has to be taken at the earliest or before the settlement of issues. If such an objection is not taken and the suit is being decided by the court, then that judgment will be binding unless and until the defendant is able to prove that the said judgment has caused miscarriage of justice, or there was some problem with him to bring the evidence or bring the witnesses or examine the witnesses at that particular place. Suppose I file the suit at Ludhiana, the defendant is residing in Madras, Chennai. All the witnesses have to come from Chennai. So I was not able to bring the witnesses from Chennai. Then I have to show that by non-production of those evidences, those witnesses, a miscarriage of justice has occurred to me. So as far as the objection is concerned, if no such objection is taken by the defendant regarding the territorial jurisdiction of the court, it cannot be allowed to be taken at the later stage. As far as the pecuniary jurisdiction, competence of the court with reference to the pecuniary limits of the jurisdiction can be allowed in the appellate or regional court unless such objection was taken in the court of the first instance. So it can be taken even at the first instance. Similarly is the case of the jurisdiction where the pecuniary limits are concerned. So as far as the competence of the executing court with reference to the local limits of the jurisdiction shall be allowed by the appellate or regional jurisdiction unless objection was taken in the executing court at the earliest possible. Even in the execution also, we can take the objection at the earliest. So all these sections have to be taken in conjunction with each other. And there are other sections, section 21A, bar on suit to set aside a decree on the objection as to place of suing. There is a bar contained in the code unless and until again there has been a miscarriage of justice. So keeping in view the territorial jurisdiction of the court is concerned, these sections have to be read in conjunction and in with reference to section 9 of the Code of Civil Procedure. I hope that I have been able to deal with the points in issue, and if there are any queries, you are free to raise the same in the comments. I will be glad to explain or redress your queries. Please subscribe to my channel if you have not already done it, because we will be having more lectures on CPC which will make the provisions of CPC very much clear to you. Thank you.